I am Dr. Shipra Gupta, Assistant Professor, Department of Laws, Punjab University, Chandigarh. I am here to give presentation on Module 5 titled Protection Against Arrest and Detention. The purpose of the module is to create awareness about the constitutional rights in case of arrest and detention. Every citizen of India has a fundamental right to personal liberty. However, arrest is a legal process resulting in deprivation of this right, which is a constitutional protection conferred by the Constitution of India. Article 22 provides the procedural safeguards against arbitrary arrest and detention. Protection of right to liberty and safety is primarily the responsibility of the state. However, in the administration of criminal justice, police play a very important role. Police atrocities and abuse of power is a sad and scary part of the system that deprives the accused of some of the valuable rights, that is, right to life and personal liberty. Arbitrary arrest and detention, violation of right to liberty and security by the police action ultimately leads to miscarriage of justice and are uncalled for in any civilized society. Article 22 seeks to protect some of the very valuable rights of the citizens so as to give meaningful protection to the persons who have been arrested and detained by the police. Unless the guilt is actually proved beyond reasonable doubt, accused cannot be treated as a convict and cannot be deprived of all the constitutional protections. Various rights have been incorporated in the Criminal Procedure Code also in order to ensure fairness in the administration of criminal justice. However, keeping in view the serious implications of the criminal action, these rights have been raised to the status of constitutional protections. The basis of Article 22 is to provide sufficient safeguard to the person to be arrested by ensuring guarantee of minimum rights provided therein. It enables to avoid miscarriage of justice and also curtails the powers of the union or the state legislatures to enact laws for preventive detention, subjecting them to certain constitutional limitations. Violation of right to liberty and security has also been considered a human rights violation. In order to make all other rights meaningful, personal liberty of every individual holds significance in a free society like ours. No person can be detained without legal sanction. Thus, no one can be deprived of his personal liberty without following the procedure laid down by the law. The right to personal liberty is a basic human right and needs to be protected at any cost. Depriving a person of this right amounts to violation of a basic right of any person. The police does not have the power to detain anyone without legal sanction. However, despite these laws, there is ample evidence of police oppression and abuse. There is a general declaration that no person shall be deprived of his personal liberty except by procedure established by law. The rights given by Article 22, Clause 1 and Clause 2 are absolute in themselves and do not depend on other laws. Articles 21 and 22 can not be treated as interrelated or interdependent. These protections are not available in case of an enemy alien and a person who is arrested or detained under any law providing for preventive detention. The police does not have the power to detain anyone without legal sanction. There is a general declaration that no person shall be deprived of his personal liberty except by procedure established by law. D.K. Basu versus State of West Bengal is a landmark judgment. In the year 1997, the Supreme Court laid down certain general guidelines keeping in view the irregularities in the procedure with respect to arrest and detention. The court directed that number 1, the police personnel carrying out the arrest should bear accurate, visible and clear identification and name tags with designation. A memo of arrest shall be prepared by the police officer at the time of the arrest. Arrestee or the detainee in custody shall be entitled to have a friend, relative or other person known to him or having interest in his welfare to be informed about his arrest. If the next friend or relative of the arrestee lives outside the district or town, police must notify the time, place of arrest and venue of custody of an arrestee to the police station of the area concerned within 8 to 12 hours. The arrestee must be made aware that the moment he is arrested, he has the right to give this information to someone. The arrest of the person and other details must be entered in the diary at the place of detention. The arrestee, as per his request, shall be examined at the time of his arrest. Major or minor injuries, if present on his or her body, must also be recorded at that time. A trained doctor on the panel of approved doctors appointed by the Director Health Services should be conducting medical examination of the arrestee, and copies of all above stated documents should be sent to Ilaka Magistrate for his record. Permission may be given to the arrestee to meet his lawyer during interrogation. The police officer causing the arrest should be communicating the information regarding the arrest to a police control room at all district and state headquarters within 12 hours. Some of the procedural protections have been provided to a person to be arrested in sections 50, 50A, 55 and 75 of the Code of Civil Procedure. Article 22, subsection 1 provides, no person who is arrested shall be detained in custody without being informed as soon as may be of the grounds of such arrest, nor shall he be denied the right to consult and to be defended by a legal practitioner of his choice. This protection against arrest provides for triology of rights. Firstly, right to be made aware about the reason or grounds of arrest as soon as the arrest is made. Secondly, right to be produced before the magistrate within 24 hours of arrest. And thirdly, right to be defended by the lawyer of own choice. Article 22, clause 1 ensures that a person's personal liberty cannot be curtailed by arrest without informing him about the reason of his arrest as soon as possible. In case of arrest by warrant or order, as the case may be, the warrant or order itself must tell him, and where there is no warrant or order, the person making the arrest must give him that information. A citizen's liberty cannot be curtailed except in accordance with law. If the arrest was made in contravention of this rule, the arrest shall be vitiated with illegality. The basis of this rule is to enable the arrested person to prepare his defense and to move the court for bail. Right to be produced before the magistrate within 24 hours is also a very important right. Article 22, clause 2 states, every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours of such arrest, excluding the time necessary for the journey from the place of arrest to the court of the magistrate, and no such person shall be detained in custody beyond the said period without the authority of the magistrate. There are corresponding provisions in the Code of Civil Procedures also, that is section 56 and section 303 of the CRPC. One of the most material safeguards is that the arrested person must be produced before a magistrate within 24 hours of such arrest, so that independent authority exercising judicial powers may without delay apply its mind to his case. It is a mandatory provision and is based on the policy of law that the magistrate before whom a prisoner is produced must be in a position to bring an independent judgment to bear on the matter. It is, however, not a mere formality, and the magistrate is supposed to apply judicial mind and not just act mechanically. Its purpose is to enable the person arrested to be released on bail or other provision made for his proper custody while the investigation is pending for the offences with which he is charged, pending an inquiry or trial. The magistrate should ensure that the arrest of the person produced before him is legal, regular and in accordance with law. The requirement to produce an arrested person before a magistrate may come to an end if he is released on bail. Article 22, clause 1, when a person arrested in relation to a cognizable offence and is first produced before a magistrate, he becomes entitled to the right to access to legal aid, to consult and to be defended by a legal practitioner. It is obligatory for such magistrate to make the arrestee fully aware of his right to consult and be defended by a legal practitioner, and that one would be provided to him from the legal aid at the expense of the state if he has no means to engage a lawyer of his choice. The Supreme Court, in a landmark judgment, Nandini Satpathy versus P.L. Dhani, the Supreme Court observed that the spirit and sense of Article 22, clause 1 is that it is a fundamental to the rule of the law that the services of a lawyer shall be available for consultation to any accused person under circumstances of near custodial interrogation. However, the lawyer cannot harangue the police, but may help his client and complain on his behalf. In Muhammad Ajmal Kasab, the recent judgment of 2012, the Supreme Court observed that it is the constitutional duty of the court to provide him with a lawyer before the commencement of the trial, even if the accused never asks for it or even if he remains silent, and this obligation is absolute. The failure to fulfill this obligation at the commencement of the trial would have the effect of vitiating the trial, the resultant conviction and sentence, if any, given to the accused. However, the failure to provide a lawyer to the accused at the pre-trial stage may not have the same consequences of vitiating the trial. In State of Madhya Pradesh versus Shobha Ram in the year 1966, the Supreme Court observed that this fundamental right given under this article is not fettered by any reasonable restriction. Any law that takes away this right offends against the Constitution. He becomes entitled to consult and to be defended by a legal practitioner of his choice as soon as he is arrested and continues so long as the effect of the arrest also continues. In Nandini Satpathi's case, in 1978, the Supreme Court commented on the spirit and sense of Article 22, Clause 1, that it is fundamental to the rule of law that the services of a lawyer shall be available for consultation to any accused person under circumstances of near custodial interrogation. In Poolpandi versus Superintendent Central Excise 1992, the court was of the view that a person summoned for interrogation is entitled to the presence of his lawyer during questioning. However, the Supreme Court in D.K. Basu issued directions to be followed as preventive measure in all cases of arrest or detention to the effect that the arrestee may be permitted to meet his lawyer during interrogation, though not throughout the interrogation. In a recent case, Directorate of Revenue Intelligence versus Jugal Kishore Samra in the year 2011, the Supreme Court did not accept the contention that the respondent is entitled as of right to the presence of his lawyer at the time of his interrogation in connection with the case. In Ajmal Kasab's case, the Supreme Court noted as follows that the right to consult and be defended by a legal practitioner is not to be interpreted as sanctioning or permitting the presence of a lawyer during police interrogation. The role of a lawyer, as per our legal system, mainly focuses on court proceedings. It is only for the purpose of resisting remand to police or judicial custody and also for the purpose of granting bail. The accused would not need a lawyer to explain to him the legal repercussions in case he intended to make a confessional statement in terms of section 164 of the CRPC. To represent him in the court after the charge sheet is submitted by the police and to decide upon the future course of proceedings, both at the stage of framing of charges and beyond that for the trial. In State of Madhya Pradesh versus Shobha Ram, the Supreme Court has pointed that the Criminal Procedure Code provides for the right to be defended by counsel, but not as a guaranteed right. The framers of the Constitution have made it a constitutional right by putting it beyond the power of any authority to alter it without the Constitution being altered. This condition cannot be altered by any authority, even on the grounds of public interest. Now coming to preventive detention. Preventive detention means detention of a person without trial and conviction by a court merely on the basis of suspicion or reasonable probability in the mind of an executive authority that the detainee has the potential of committing prejudicial act. Preventive detention has been regarded as sinister looking feature out of place in a democratic constitution necessarily designed to prevent the abuse of freedom by antisocial and subversive elements which might imperil the national welfare. It was observed by the Supreme Court in A.K. Gopalan versus State of Madras. Another judgment of the Supreme Court in the year 1981, Francis Correll Mullin versus Administrator Union of India, the Supreme Court has said that it is preventive, not punitive in theory. The purpose of preventive detention is not to punish an individual for any wrong done by him, but to curtail his liberty with a view to preempt him from indulging in conduct injurious to the society. It is a drastic power to detain a person without trial, and in many countries it is not allowed to be exercised except in times of war or aggression. The Indian Constitution recognizes preventive detention even in peacetime. The power of preventive detention is a frightful and awesome power with drastic consequences affecting personal liberty, which is the most cherished and prized possession of man in a civilized society. The law of preventive detention must, therefore, pass the test not only of Article 22, but also of Article 21. It is a power to be exercised with the greatest care and caution, and the courts have to be ever vigilant to see that this power is not abused or misused, in as much as the preventive detention is qualitatively different from punitive detention and their purposes are also different. In case of punitive detention, the person has fullest opportunity to defend himself, while in case of preventive detention, the opportunity that he has for contesting the action of the executive, that is very limited. Therefore, the restrictions placed on a person preventively detained must consistently with the effectiveness of detention be also minimal. Various safeguards against the order of preventive detention have been provided under Article 22, Clause 4 to Clause 7. Article 22, Clauses 4 to 7 lay down a few safeguards and provide for minimum procedure to be observed in case of preventive detention. Any law or administrative action relating to preventive detention infringing these safeguards would be rendered invalid as infringing the fundamental rights of the detainee. The safeguards aim at protecting the liberty of detainee against bureaucratic lethargy, insensitivity, red tape and casual approach. Article 22, Clause 5 provides that when any person is detained in pursuance of an order made under any law providing for preventive detention, the authority making the order shall, as soon as may be communicated to such person, the grounds on which the order has been made and shall afford him the earliest opportunity of making a representation against the order. There is dual obligation on the detaining authority to communicate the grounds of detention to the detainee at the earliest, and secondly, to afford him the earliest opportunity of making a representation against the detention order, which implies the duty to consider and decide the representation when made as soon as possible. Import of Article 22 Clause 5 is to make the right of representation effective. All facts and particulars which influence the detaining authority in arriving at its satisfaction, or copies of material documents considered, relied upon by the detaining authority in arriving at its satisfaction to detain the detainee, must be communicated to the detainee, without which effective representation is not possible. Factors vitiating the detention, vague grounds supplied to the detainee, or in a language with which he is not conversant, non-consideration by the government of the representation filed by a counsel on behalf of the detainee. Right to consult legal advisor of his choice extends also for securing release from preventive detention or filing a writ petition, etc. The right of detainee to consult a legal advisor of his choice is included in right to live with human dignity and is also a part of personal liberty. He cannot be deprived of this right except in accordance with reasonable, fair and just procedure established by a valid law. Speaking on the importance of right to representation, the Supreme Court in Mohinuddin versus District Magistrate in the year 1987 observed with emphasis that the right of representation under Article 22 Clause 5 is a valuable constitutional right and is not a mere formality. Obligation of the detaining authority to afford the earliest opportunity to detainee to make representation embodies the constitutional right to a proper and expeditious consideration of the representation by the authority concerned. Commenting on the effect of delay, the Supreme Court in T.A. Abdul Rahman versus State of Kerala in 1989 observed that the unexplained undue long delay between the prejudicial activity and making of the order of detention renders the order of detention vulnerable, liable to be quashed. The court is required to be cautious and pragmatic while dealing with the question of delay in making an order of detention. Unsatisfactory and unexplained delay between the date of order of detention and the date of securing the arrest of the detainee would throw considerable doubt on the genuineness of the subjective satisfaction of the detaining authority. In a recent judgment of Rishikesh Tanaji versus State of Maharashtra 2012, the court pointed out that it is important in cases where a detainee is released on bail under the order of court, at the time of passing the order of detention, such order of bail must be placed before the detaining authority to enable him to reach at the proper satisfaction. Otherwise, it would vitiate the subjective decision of the detaining authority. In another case, Rika versus State of Tamil Nadu in the year 2011, the court observed that detention order would be bad if the detaining authority is not made aware that the bail application of the detainee was pending when the detention order was passed. Another safeguard provided by Article 22 Clause 4 is that preventive detention for over 3 months is possible only when an advisory board holds that, in its opinion, that there is sufficient cause for such detention. The detention of a citizen for more than 3 months as per the law made by the state, which contained no provision for an advisory board for giving opinion as to whether the detention is with sufficient cause, will be unconstitutional. This was clarified by the Kerala High Court in Anitha Bruce versus State of Kerala in 2008. The judicial decision has so far established that not only the advisory board should report about its opinion regarding sufficiency of cause for the detention of the detainee within 3 months of the date of detention order, but that the government should also confirm and extend the period of detention beyond 3 months within this 3 months time limit. Article 22 clause 4 states, no law providing for preventive detention shall authorize the detention of a person for a longer period than 3 months unless a. an advisory board consisting of persons who are or have been or are qualified to be appointed as judges of a high court has reported before the expiration of the said period of 3 months that there is, in its opinion, sufficient cause for such detention, provided that nothing in this subclause shall authorize the detention of any person beyond the maximum period prescribed by any law made by Parliament under subclause B of clause 7, or clause B says such person is detained in accordance with the provisions of any law made by Parliament under subclauses A and B of clause 7. Article 22 clause 7 confers some powers to the Parliament. It states, Parliament may by law prescribe the circumstances under which and the class or classes in which a person may be detained for a period longer than 3 months under any law providing for preventive detention without obtaining the opinion of an advisory board in accordance with the provisions of subclause A of clause 4. B says the maximum period for which any person may in any class or classes of cases be detained under any law providing for preventive detention, and clause C, the procedure to be followed by an advisory board in an inquiry under subclause A of clause 4. Clause 7 of article 22 confers power on the Parliament to make a law prescribing the maximum period for which any person may in any class or classes of cases be detained under any law providing for preventive detention. Article 22 clause 7 subclause A is an exception to article 22 clause 4 and should only be used in extraordinary and exceptional circumstances. Article 22 clause 7 subclause A empowers only the Parliament and not the state legislature for making such a law that does away with the requirement of obtaining the opinion of the advisory board. To conclude, though protection is guaranteed to the citizens of India against arrest and detention, but in certain cases there may be deviation of normal procedure subject to provisions of the Constitution of India. Police, being the law enforcement agency, has to be given certain powers. To avoid the probable chances of misuse of this power, certain procedural safeguards have been afforded to the accused. Thank you.